Ambastha, co-founder of IP Bazaar. He is an accomplished intellectual property attorney with over 20 years of experience in IP law, licensing, valuation, and technology transfer, specializing in bridging industry and academia for technology commercialization. Founder of Patent Wire and co-founder of IP Bazaar, he serves as a recognized thought leader under the Ministry of MSME and as guest faculty at institutions including the University of Strasbourg, IIT Guwahati, NIFT, and Jamia Hamdard. May I now request Mr. Lalit Ambastha to address the audience.
Good evening and Jai Hind to everyone. So entire day we were talking about the body of the business. Now we will talk about the soul of the business, right? This is IP. So do you believe IP is the backbone of business? Do you agree?
Yes.
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 So are we talking?
Yes. Listening.
So I have prepared a slide. This slide is based on the first fact, divided into three parts. One is what is IP, obviously the basic aspects. Obviously you guys are aware about each and every aspect, but I will touch upon certain attorney part, certain outcome part, and then how you can acquire this IP and what is the relevance with this system, how you can harness out of these when you acquire the IP. So this is all about. So IP as a business strategy for all CXO. So I believe each and everyone is CXO, right? So founder, co-founder. So why Apple is big? When Apple iPhone launched in 2007, they have already filed 73 patent applications. And in India, most of the company, they are filing hardly 50 patent in entire 100 years, right? So when they have launched, they have filed. And I'm talking about when you file patent in India, it will cost you hardly 50,000 rupees. Because you know in India we believe in L1 also, right? So we go for the cost. So Indian IP cost is 50,000. What about US patent filing cost? Somewhere around $10,000, $20,000 for one patent application. And they have invested 73 such patent, right? And then currently they are having how many patent applications? In just iPhone, 38,000 patent applications. So how they are competing with the business? The competitive analysis, how they are doing? They are negating their own patent in each every day through their R&D team. How? They are filing and they are filing again. So that the people the other competitor cannot file, cannot even think. And in this way they are leading the entire world. So I'm talking about the intangible asset. So whenever we are talking about the total asset, a total value of any enterprises, two things we calculate. One is tangible, one is intangible. In India, we believe in tangible, right? Mostly. So this part, if I say Apple is, well, these are all intangible. If you see, they have filed more than 48,000 patent applications. They are not just into the mobile, they are into many other things. They have design also. They have more than 2,000 plus trademark applications and copyright also, trade secret also. And apart from that, there are various critical intangible assets that we are aware, customer data, and obviously these are billion of worth. So that is why Apple is Apple. So if we wish to go bigger, we have to think big, right? But whether we are in line, that is also a question mark. Because whatever I will talk about the database, what database source. Because patent database, what we are using, it's not Google, it's a patent database of somewhere around 192 countries. You search and you can gauge easily that how many patent applications we are filing. Many times we are saying that we are not filing because we are from defense. There are certain critical aspects, there is no need to file. Then why Israel is filing? Then why Russia is filing? Then why US is filing? If there is possibility to do the reverse engineering, suppose AK-47, I can assemble and and again reassemble, right? Then there is no need to keep trade secret. You have to file. You are bound to file because anyone can reproduce. If there are possibility where there is no possibility of reverse engineering, then only we are hiding. And that is why Coca-Cola is a trade secret. So when we are saying that, we are not filing because people will get to know this is not the right answer, right? Otherwise, why Apple is filing? Why other people are filing? So coming back to basic aspect impact of IP. What is the impact of IP? Why I am saying loudly, right? So this is about the Standard and Poor organization, 500 Fortune companies, Fortune 500 companies work. They are doing this since decades. So in 1975, when Fortune 500 companies listed was something else, they have calculated the tangible versus intangible and they have listed. The current day, the Fortune 500 company list is entirely different, right? So 17% here is about worth of their intangible asset out of their total asset. After 10 years, the intangible asset converted into 32%, and then after 10 years converted to 68%, and then 80%, and 2005 it converted to 84%, and currently it is 90%. So now you correlate with any of your Indian company, whatever company, right? We are patent attorney, we are filing many of big players patent application, and for your information, for many of big players, we have filed their first patent application recently. Recently we have filed their first patent application. I am talking about Fortune 100 or 50 companies of India. So why? Because we do business in an entirely different manner. So if you see how it is coming out, how they are filing, why they are filing. So it's all about the leadership, it's all about the broader mind. So for your example, GE, the founder of GE is, who is the founder of GE? Thomas Alva Edison. Thomas Alva Edison. So currently GE is having, I think, more than 75,000 patent applications. And if you see, this is the top five company in 1975, and GE was on third. After 10 years, GE is on fourth and then third, and then first. Until 2005, GE was on entire world topmost. So what leadership Thomas Alva Edison has given to their entire team. After IT revolution, obviously they are among top 20, still they are, and they are into defense, they are still manufacturing bulk. But apart from that, they are manufacturing everything. So it's all about your vision. So that is why this lecture is about CXO. So what is your vision, and the same vision will go down and the company will run. This is the ideology behind the IP. Correct me if I'm wrong, I'm saying right thing. Coming out well?
Yes.
So obviously you guys are aware about IP. So IP, when we say IP is always international law. And in IP, there are types of IP. And internationally, we are part of TRIPS. We have signed the agreement, WTO agreement in 1995. As per TRIPS, before signing the TRIPS, we were having just two IP law. Because of TRIPS signing WIPO agreement, WTO agreement, we were bound to implement each and every law. And because of that TRIPS agreement, we have implemented entire law within 5 years. Till 99, we have implemented all 7 type of IP, one IP type we have not implemented yet. So if you see what we are doing through our intellect, whatever is coming out from our intellect is a part of IP. So through our intellect, what we are doing, we are creating Google, we are reaching to moon, we are also writing script, lyrics, whatever things that we are doing through our mind. This is part of under the intellectual property. But the irony is, most of the time we are not teaching it in any curriculum. Whatever is coming out, we are not teaching at our curriculum. Even in law, IP is always an optional paper, right? So if you see, what are the types of IP? One is trademark, design, copyright, SIC layout, semiconductor integrated circuit layout, patents, plant variety act, and then geographical indication and trade secret. Currently, we do not have an act for trade secret. We are still doing through our civil procedure part. Apart from that, we have a separate act for each and every types of IP. So when we say IP means these are the IP, and we are IP attorney. We are handling all these aspects, and whenever we are talking about any technology or any product or any company, we are talking about their entire different types of IP. It might possible sometime be confused. We are talking that we wanted to file our brand name as a patent. Now days change, right? Since last 5 years, we are not talking in this way. Now we are talking very sensible that we wanted to file design. We wanted to file trademark. So India is also evolving. This is also required. So if I say what is the relevance of defense? So if you see trademark, there are Tejas, we are talking about Brahmos, we are talking about, these are what? These are brand or certain intangible aspects. So these might be a trademark, right? And then when we are talking about patent, we are talking about jet propulsion, and there are technology involved, radar. These are what technology. When we say copyright, then there are software. There are several software. Then when we are talking about SIC layout, then we are talking about the semiconductor integrated circuit. And then we are talking about design, then we are talking about the design of the or the look. So there is a difference between patent and design. So whatever we are seeing through our eyes, this is the design, like tank, T90 tank, right? So whatever helmet, there are so many different types of helmets. So these are part of the design, and the plant variety, you are aware that we are upgrading our varieties, and whatever things we are doing, like green revolution, one of the example of the PPBF. And then GI, we are aware about, we are the mother of all GI. India is mother of all GI, like our Banarsi sari and the Shweta and all that. So these are part of GI, Basmati, Darjeeling. Trade secret is also a part where we always say that if you wish to protect through your trade secret, you can keep it. But trade secret is very expensive because you have to manage in your organization, because leakage mostly happen from your organization only. So whosoever is managing is very expensive. So if you feel that nobody can do the reverse engineering while the product into the market, and nobody can do the reverse engineering, you keep the secret. There is no issue, no challenge. But if it is possible, then there is no need to, like Iron Dome technology, they have filed several patent applications. They have filed 100 plus patent application in Iron Dome technology, and it is in public domain since 2013. So you can download within 20 seconds. Each and every part, each and every statement, you can download. So I will also go through how patent system is working, how information is we can get, how we can improve from the patent, and how we can evolve from the patent, and how ethically we can use. And the question the same, whether if we are making a copy of the patent through our Indian sources, whether this is an infringement or not infringement. We will also check, right? So I'm coming back to patent system because there are several types of IP, but patent system is more lucrative in terms of the business aspect. So when we file patent system, why patent different? Why patent system legislation evolved? What was the requirement when they have introduced, and then what happened? So if you go back to 1612. West has introduced the patent system. The ideology was that during war and all that, our history, when you go back during Mahabharata, we were having the knowledge of entire technology, but we have not documented. Guru Dronacharya has not documented how to drive the Brahmastra, right? So they have evolved through a new concept. Why not to ask each and every entrepreneur or intellectual people to disclose your idea in such a manner that we can reproduce directly the same thing. So suppose if we have to drive the Brahmastra and there are so much stanza of Om, and you have to disclose each and every stanza of Om in such a way that anyone after the expiry of that patent can actually drive the Brahmastra. This is the idea behind patent document. So when you read the patent document, you are actually visualizing the product in right manner. Like we are writing patent documents, so we are aware. We are asking each and every information, how the system is talking with other system, how subsystem is working, how it is working in ecosystem. Everything we are disclosing in the patent document. So when I'm saying that Iron Dome technology is available, I'm not saying that this is available. If you are a learned people, you can actually evolve through the technology and you can also design around. But the question is whether this is written in plain English. This is written in techno-legal language. So if you know the techno-legal language, and for learned like you, it will take hardly 1 hour to understand the techno-legal language. It's not, this is a jargon that we are using because obviously we have to also run our business, right? But this is a 1 hour session. You can take and you can understand patent document easily. Where to read, how to extract, how to go through and how to evolve, right? So this is the criteria. So when we are saying that I'm going to file patent application, we are actually providing them actual recipe of the patent and then legal exclusivity when we are filing and getting a grant. That means I have a monopoly. I have government has given I have built a road and government has permission that only you can go and you will allow the people will go. Nobody else will go. This is the beauty of the patent system or IP system. This is called negative right. In any other law, this is not the provision. In IP only we have a provision. This is called negative law. I have a monopoly till 20 years as per patent law. So I have filed and I have a 20 years I can use, though there are certain provision for defense, because for defense only, for government only, not from any other people, right? But there are legal exclusivity and then there is an innovation incentive. What is innovation incentive? If I have a 20 years timeline, I can make money. I can make money out of that. For your example, do you know who has invented dynamite?
Noble.
Alfred Nobel, right? Alfred Nobel, the Nobel Prize is actually from the Alfred Nobel. He has donated entire amount that he earned in 19th century. And he has donated entire amount, and by that amount still we are paying that Nobel Prize. So this is the beauty of harnessing the money. So Alfred Nobel was inventor, and so in the similar way, if you use patent as a knowledge access, because whatever database we are using is a very use. So we are having access of 192 country database. I can see, I can check. If you file patent application, government will not give you a grant. There is a provision of publication. They publish first and then they grant. So you can check before grant. So whatever document we are checking, we can also check that somebody has steal my idea and file the patent application, but is still under the grant stage. I can oppose. There is a provision. Just like we are publishing in PIB and all that, we are involving public at large. If you wish to oppose, you can oppose. That is the idea behind publication of each and every patent application. That means even Thomas Alva Edison bulk patent you can access. You can download directly without paying any penny. So in the similar way, whatever technology you can download, and this is not that you are stealing some idea. You can control over each and every document. You can download, you can keep, you can evolve. This is the beauty, and then strategic intelligence you can use, and then technology advancement as per, because this, if I say patent document itself is a gold mine. If I am stuck at certain place, I can go and I can check how NASA is doing, how US Department is doing, how they have disclosed, how they have filed, and these are not like a standard document where these are locked, where you have to pay. You can download easily within 20 seconds, and then you evolve and you advance through that knowledge. This is the beauty of the IP, right? Any doubt? So these are some national security provision. So suppose, like you said about the patent aspect, right? That whether if the requirement is such that the OEM is not providing certain parts, and because of certain part, my product is facing a challenge, then what I will do? Government or defense has power as per the act, and these article or these even as per the article TRIPS, under TRIPS 73, they are saying that for exceptional reason, for security and sovereignty reason, you can use a patent and nobody will challenge. There is also a provision how apart from the government and the defense people, how other people can use. There is a terminology called compulsory license. if some certain body has taken a patent but they are not doing anything, and there is a requirement under COVID or whatever, we can file a compulsory license and we can get. So other patent we can use by the, obviously by the intervention of government. This is already there in the act and we are invoking. But irony is, for compulsory license, for defense and all that, I am not aware because these are classified document as well. But for compulsory license, India has just given one. Just one compulsory license till now granted. So we are not even using. So if you feel that certain player, they are big enough and they are not utilizing patent in a right manner, as a private party you can invoke and you can get. This is the provision within the act. So we have to utilize, because we many times we are not knowing these information, and that is why we are not using. And that is why I said business is all about soul and body. So this is soul, right? So if you have an idea about this soul, you can do a better. Yeah. So one more aspect, and then I will touch upon how you can acquire IP. So this is about filing system. So entire filing system is very beautifully crafted. So there are many questions people are asking, that suppose today I have filed and it is going to publish, then many people will copy. Then what will happen? How I will get my reward? So blah blah blah. There are so many things. Whatever you are saying, this is the same problem for Microsoft, Dell, Apple, how they are filing. If in India, if grant we are giving after 3 years, so we are giving to grant to Indian people as well as Microsoft as well as Apple. So the same challenge with them, because in IP there is a terminology that we are using that is called national treatment. What is the meaning of national treatment? We will not discriminate on the basis of they are foreign player. We will not ask more money to pay. So suppose in India for filing fees is 1600 rupees only. This is for foreigner as well. They have to also pay 1600 rupees. For US, the filing fees is $1600. This is apply for Indian as well. They have to pay $1600. This is because of the financial reason. But this is true. So we are not discriminating. IP is not discriminating on the basis of your foreign nationality. And one more thing, you can invoke your right anywhere in the world, because having your right without having any office in that jurisdiction. So suppose you have IP in Netherlands or Nigeria, whatever, you can invoke your right from here only. You need not to go any court and you can invoke. You have the same privilege as their local. This is the beauty, right? So how it is starting? Suppose today I wanted to file a patent application. I can file, since I am an Indian national, Indian company, I have to file in India first. This is as per law. If I am from US, then I have to file first in US. If I wanted to file directly in US, then I have to take permission. The same with the US. This is as per law. So first, suppose I have filed in India, then the same draft will go to each and every jurisdiction, because law is always territorial. There is a Lakshman Rekha, right? What is the meaning of Lakshman Rekha? There is a territory. So what is happening? You file in India, whatever we have filed, suppose you have filed love letter, the same love letter will go to each and every country. So that is why there is a beauty that when you are crafting your patent, you have to craft in such a way that it will qualify in US and Europe in equal manner. So your drafting must be tight and as per the standard, so that when it will be examined in US and Europe, it will be having the same quality. So whatever we are drafting as per the quality standard as we are filing in US. Whatever we are working at par with the US attorney and European attorney, because there is no difference. We have the same standard, and this is not in any other law. Even in the state law, we have a different wakalatnama, right? The format of wakalatnama is entirely different. So suppose we have filed in India, so there are two provisions to file different countries. There is a practically impossible aspect that we have a global patent. There is no term global patent, because nobody is interested to file in 192 countries, right? So how they are filing in different countries? Suppose I have a need to file in 10 countries only. Then we have two provisions. One is called Paris Convention. Within 12 months, you have to file in entire 10 countries. After the expiry of the 12 AM of that 12-month deadline, you are not allowed to file in any jurisdiction. This is one aspect. Because they have given you 12-month timeline, the same application number, same priority date, same Indian number, they will ask. Suppose I am going to file in Europe, they will ask about Indian application number and Indian priority date. And if it is exceeding 12 months, then they will not allow to file. That means, what happened then? You have a right in India only, and it is generic to entire world. The term generic is coming from this particular aspect, that they have filed in India, but they have missed the deadline, or the 20 years timeline already elapsed. So generic term is coming from the two term, and many times we are confusing. We are confused on generic. What is generic? Generic means free to use. How it will be done? Suppose a pharma product that filed in India, but we missed the deadline. That means in entire world except India, my technology is generic. Or after 20 years of expiry, if I suppose I got the grant, then it will be generic, right? So that there is one provision, and since within 12 months it is almost impossible to capture entire globe, or even think about that I have to file more 10 countries, I can file reduced country. So all such things are the problem. So within 12 months it is not possible. So then there is a different provision that is called PCT, Patent Cooperation Treaty. Here there are 154 countries are member. So what they say is that you file one application, the same application you file before Geneva, WIPO office, and then they will give you further 18-month extension to file European or US or Chinese application. So now you have 30-month deadline to file your first Indian application to anywhere in the world. After 30 months, it is generic in entire world except wherever you have filed. So now consider, Germany is filing 90,000 patent application in a year. Germany, because we are very blind about the German technology, right? So they are filing 90,000 patent application. In India, each and every year, they are filing hardly 1,000 patent applications. Hardly 1,000. That means what? After 2 years, the same 89,000 patent application is generic for Indian territory. You can use as it is. You can copy as it is. Nobody will touch you. Why? Because they do not have right in Indian territory. Whether we are doing like RF, STR, whatever technology, you just check whether they have filed or not, whether the timeline already lapsed. If lapsed, they have not filed, copy each and every word, produce your product because it is written in such a way, and then accept. But whether we are aware, because now we are talking about ethical. No, this is not right, we can't do this, but this is ethical. This is as per law. Right? Any question, any doubt? And if you are suppose you are searching and you found certain technology related to your, and trust me, I can give you a letter that this is not filed in India and you are free to use, nobody will touch you. Right? This is as per law, and this is very ethical. So next part is how. So now coming to how we can acquire these IP. So IP in terms of like this semiconductor in Rafale, in Tejas, there are so many semiconductor aspects: power, processing, communication, sensing, intelligence. These are different domains where semiconductor is applied. So these are where we are. There, this is written. So I am also highlighting the patent number because we have access and whatever data I am giving is a real. So 90% correct. So if you 2.5 lakh patent application you can download, you can replicate if it is not filed in India. Right? So obviously IP, India is precision IP but not yet scale IP. This is one domain. There are so many other domains where we have a very less presence in terms of the technology. So make in India, obviously when we say make in India, that means assembling. Design in India means developing. Patent in India, protecting. And own in India means controlling. How we will control. And now we are talking as per DAP, Defense Acquisition Procedure, we are saying it loudly that this is not about make in India, this is about own in India. How you will own it? After crossing these areas. When you develop, when you protect, then only you can own. right?
Very nice.
So the same thing, ethical aspect, responsible knowledge. Whenever you are using obviously patent information, you have to take care of these aspects. Then there is no problem. Responsible knowledge use, respect legal boundaries, ethical design around, and innovation through learning. Because these are the process, and trust me, these are available for you free of cost. There is no need of any AI. Cloud पे नहीं मिलेगा, chat पे नहीं मिलेगा. Google का अपना platform है. You just Google patent and you type your technology will get the information and then create improved solution. So these are for you where you can develop, you can excel. And what is how you can harness now from if you have IP. So what is innovation system? So innovation ecosystem, there are several terminology that we are using, exclusive license. These are terminology, TRL, now we are talking. MRL is also there, right? So now we have started talking MRL, TRL, patent valuation, and these terminology now very upcoming in India, and that is very good sign. So coming back to innovation mantra, how you can, suppose you wanted to develop your IP portfolio or IP based startup, how you can start. So first, suppose you have not done anything, so first you discover, there is a terminology that we are using, discover, defend, diversify and evolve. So how you can discover, there is the service that we are providing that is called white space analysis. You check whether whatever you are thinking in RF, whatever you are thinking in SDR, whatever you are thinking in defense, whether there is a noise or collision. You check that and you can check easily. We even in our IP Bazaar portal we have uploaded more than 30 plus such white space report where there is a very less number of patents. Like tantalum is one of the part. India has no presence. Tantalum extraction and recycling. If you wish, you can start. These are white space. So where you can discover first, and then what you can do, you check your competitor, check the freedom to operate, upstream and downstream player, and in the similar way, diversify IP ecosystem and competitiveness, and then evolve of landscape. These are the part that we are doing, and each and every segment we are helping our client to grow. So we are not just patent attorney, we are IP strategists. So we are utilizing, because IP is the backbone. So we are providing them backbone. Though you can run, you can crawl, but when you have a backbone, then you can run like human body, right? So IP is like that. So in the similar way, in the same how you can value creation pathway. So how you can create, first part is obviously ideation path. You check that, you discover well. So first is ideation path we are teaching to startup in many forum. And for this particular part, there are 2 hours session also, how you can ideate. So ideation, and then there is a validation path. If your idea is good and you have validated enough, and then qualification path, because as per defense, because I am talking about the defense procurement, so there is a qualification aspect. You qualify as per the defense mandate or standard, and then go for acquisition path, how you can utilize, and then go for a commercialization path, and then finally expansion path. So this is the overall, but within one terminology there are many things. 2 hour session, there are many sessions, but these are need to know for CXO. And most of the time people are not even aware, right? In board meeting, IP we are not discussing. But this is very much related to that, and IP is not about just patent filing or trademark filing. IP is all about how to strategize your entire thing. So that you are aware, defense acquisition procedure draft recently came in March, and this draft is saying directly, right, that IP, if you check the draft is a 158 pages. IP is no longer merely a legal asset as per the draft. It is becoming a procurement asset. They are talking about. So I have taken the terminology. So no IP, no indigenous design claim. So how you can, so no IP, no indigenous design claim. You cannot claim that you are indigenous design. IP strengthen, eligibility. So if you have IP strengthen, then you have the eligibility. In a similar way, patent creates procurement credibility. And then source code ownership is the new strategy asset as per the tag. And then IP reduces foreign dependency, they are talking about, and then IP support life cycle. Life cycle means you will get more and more project because of your IP. So in the similar way, if you see, scoring advantage, they are talking about if L1, for L1 itself, if you have IP, you have a preference over L1. They are saying if L1 is not having any IP but you have IP, there is a preference aspect in L1. Patent, copyright, trade secret equals to procurement differentiator. They are talking about this is draft. It may be implemented soon. And then IP portfolio demonstrates owned by India. So obviously, made in India to owned by India. If you have your slogan is along with that, then you will win the race. So this is as per that. And finally, this is all about IP value driver. Order shows market acceptance. IP shows future potential. TRL proves technology maturity, but IP proves ownership. So when we are talking about TRL only, like in TRL progression, mostly what is happening in TRL, we have filed first patent application and we move from TRL 0 to TRL 9. We have not filed any single patent application. TRL means you have to file each and every stage, TRL 1, 2, 3, 4, 5, more and more patent applications so that you have a control, ownership. But we are not even considering, we are in the maturity. And many times we have rejected because they have started with TRL 0 and they have wanted to sell the TRL 9 product with the same TRL 0 patent. That is not possible because you have modified. In the similar way, MRL proves production capability, IP proves wealth creation capability. This is about a value driver. And then made in India to own in India, because this is the slogan of that. So there are three aspects: indigenous patent and IP, developed and owned in India. This is the meaning of indigenous patent. Successful TOT means technology absorbed and localized. An indigenous development program, Indian design and development leading to procurement. So we are proud to say we have many such examples. And when we are talking about TOT, we have taken and absorbed and then evolved. So obviously you have to take care of IP aspect. If you are infringing, then they will not allow. So if it is expired patent application, what is happening like German and all that, European people, they are dealing with government or private player. Like that we have a patent, granted patent. But they are not saying that this is an Indian patent and we are doing a license. Though this technology is no meaning in India, but we are signing and we are giving all sort of money without even checking the patent document. Because whether it might possible that in the patent document itself, the recipe is already given. Why we are buying the product, why we are dismantling and then we are evolving. Just check the patent document, it will cost 0. And then develop. If it is not possible, then buy the product. This we are doing many times. We are buying a product. So if you see, these are our proudful moment, like Akash Air Defense System. This is a part of indigenous patent, and these are from successful T2 BrahMos, Sukhoi, T90. These are part. Some are the indigenous stages and all that. So these are our part, and we are proud of that. But we need more and more such examples. And many times I ask that in the conference room, what technology we are using that is of Indian origin. We hardly say one technology, even the watch, specs, whatever, right? In Indian origin technology, we are struggling to find, and that is the problem, right? So this is all about. This is the report that license production create factories, because you can take Rafale and AK-47, it will create factories.
Super.
Technology transfer creates capability, because now you have a capability. But indigenous IP create a strategic autonomy. We export long-term and this is the idea that we are telling, that IP is the backbone and the soul of the entire business model. That's all from my side. Thank you so much.
We shall take 2 questions, but before I open that to the audience, I must tell you the knowledge, technological knowledge which is available in the IP, which is easily available for all of us to copy, has got so much wealth, you cannot appreciate that. Any organic R&D which will take a decade can be done in 2 years time. Anything which you can do by organic R&D in 3 to 4 years can be done in months. And we have taken 2 test cases on the software defined radio and Tantulum, this thing, and proved, and therefore a policy decision has been taken in DRDO, at least in their 82 labs, that the IP examination is going to be a fundamental process before they invest in R&D. So even if you are a startup or MSME, if you are going to research on a particular project, you want to develop a particular project, please examine the IP based data available. Maybe at your end you may not be able to decipher the entire content. Maybe if there are some Chinese patents, some infractuous inputs are given which you need to verify through the lab testings. But the western portions, from US, European countries, most of the IP filings have got the accurate details, near accurate details, and most of your work is already done. And then Indian Patent Act 1970 gives you option for the defense domain working, that anything can be copied or reverse engineered or whatever with the latest and that convenient. There's just no legal restriction of any kind. So this is just a thought I wish to leave before you ask questions. So we will just take 2 questions because of time. Anyone?
Lalit, I firstly for a very good presentation here. I'm here.
Okay.
So you said that having an IP could also lead to something in the gap procurement. So is this just a hunch, a perception, or is it documented in the draft AP document? So in what terms would preference build? Like if you have a QC-based system in terms of percentage, something, what additional marks?
There are 158 pages. I think you can also go through that. They are saying that if you have IP, because then they are saying that you are indigenous company, right, developing technology, you must have IP. So they are asking that what are the IP document that you are providing us. If there are 2 companies competing together, then IP, whosoever having IP, they will give the privilege. So
No, see, in a bid you have a technical bid and a commercial bid.
Yeah.
So my question is it going to be used for the technical bidding or would they have a commercial component as well?
So I think they are talking about both aspects, technical as well as the commercial aspect, because they are also saying that if L1 is coming and they are not having any IP, but you are having IP, so they will provide you the privilege on that L1 aspect as well.
I think Manik, there is another aspect to this. Let's say suppose you say ki I have got 60% indigenous content. Now how do you justify, So if you have already filed IPs by yourself, or let's say there is an IP filed by anybody, Indian company in that particular component, then you can say, okay, these are the things, and this is the Indian owned thing, whether by me or by this thing. So the authentic declaration of the indigenous component has got a direct connection with the IP linkages.
Lalit, I would like to tell you each LinkedIn post the 2 hashtags, technological sovereignty and owned in Bharat as my system. And thanks for a lovely presentation.
Thank you.
Now,
Thank you. Congratulations on a fantastic presentation. Just a quick question. Given how critical IP is now to DAP 2026, and given that this is going to be critical to startups and so on responding to DAP 2026, to what extent would you advise startup founders to strategize and prepare for patent cloning? These are large, complicated technology platforms. There's a very, very rich intellectual property base over here, and not all patenters, including those abroad, are very benevolent. So, is this just a shadow threat? You don't have to worry about it, or should they prepare for it and talk to the IP lawyers early?
I have 2 answers. One is obviously the threat also, because if you see many of the IP area where we have a futuristic technology that we are aiming, even DRDO is aiming on, or whosoever government is, even the private player, the foreign player, they are filing heavily. So that means what they are actually locking in terms of the IP, because whenever you will start commercializing, they will set you the notice, because they are filing, and this is the biggest threat. In certain area, we have seen that like critical mineral areas and all that, there is no presence from the foreign player. Though there are patent applications in China, because China is heavily filing, and China has changed since the 2012 only, not before that. Like I came in this field in 2005 when India was filing 2000 patent applications total. Now we are filing 1 lakh plus patent applications. China has in 2011 they were filing a similar patent application. Suddenly they have started filing 1 lakh, 2 lakh. Now they are filing 14 lakh patent applications. How they are filing? They are filing through the same research paper that IIT Madras professor has uploaded, or somebody has uploaded. They are filing 10 of patent applications. And trust me, patent filing is not a complex. We are not wanted to sit along with the attorney to hear, and we do not want to listen half an hour lecture. That is all about it. So if you say that complex, this is not complex.
No, I think technology is complex. The IP filing is not. It just because emerging technology is so diverse.
Yes.
Because emerging technology is defined by first mover advantage, regulatory solve because of patent
Yes.
monopolies and data network effects. I'm wondering, in that context, is it not advisable for startups to think about, if you're thinking about first mover advantage in technology, then think about the same intellectual.
So that is why I've given the innovation mantra, right? You have to first discover, whether you are going to head on, or you have to take a highway, right? So like me, how they are managing the entire different portfolio. They are maintaining because they have a team. Even the KPMG and EY, how they are managing so much services. They have 4 people in one department and they are dealing everything. So in the similar way, startup is not even accepting the fact that patent will lead to the business. That is the mindset that we are facing, because I am discussing with many of the startups. They are bluntly saying that the patents in a business way. That they are saying correctly. So if they are saying that, if they have a mindset like this and they are into the defense technology high end, then how you can? And whenever we are saying, because who can say, patent attorney can say, right? But they are saying that if Lalit is saying that means he wanted to do business, his business, and that is the irony. And I believe that it should be in the classroom, from the school, not from the colleges, and we are not teaching. IP is not part of our curriculum, and that is the fact. And that is the reason that whosoever is our co-founder, they are not even aware that this is a requirement. Yeah. And I don't think that anything is complex. I said about patent drafting itself, 1 hour you devote, you will learn everything. But whosoever, we don't want it to learn. Yeah.
The last question of the day.
Yes.
He will appear again tomorrow on the TRL issue, so balance thing can be taken up tomorrow.
Yeah. No, I just wanted to ask that because you mentioned for defense procurement, especially for indigenous, content measurement, IP is considered. But for most of the companies, especially space tech and everything, they're generating a lot of IPs on a day-to-day basis. But filing and being granted would take time. So I wanted to ask from people, whoever is the concerned people here, that let's say we have some competitive another entity for a given service, and they have filed the IP, it's in process but haven't been granted. Then how is it measured, or this competition is broken?
That is in DAP itself. They are saying about the granted and the under the prosecution part, right? And if you say India has changed, so now they are giving you grant within a year also. I have given a grant within 6 months also. Earlier it was 8 years, and trust me, for doing business, there is no requirement of grant certificate. If you have a technology, you have filed, you have protected, then you can stop competitor. That is a requirement. Why 90% of the startup is failing in India? Because we are not protecting our IP. Everything we are creating a generic aspect. We are giving to entire world that you copy, and then we wanted to that and we failed, right? So protection is a requirement. And even TRIPS says that whosoever will file first, they will get the patent. This is the law, right? So you file first, forget about the grant. It will take time, and it will come to you. And you have each and every right.
I mean, time is fine. I wanted to know about the people how they consider it when it is still in the process.
So they are given the certain mathematics. I have not gone through the entire 158 pages.
Okay.
But you can check. And I think this is a draft, so I think there is a requirement of more and more addition also. I think you can also comment, and then they can check.
Understood. Thank you.
Thank you so much.
I was looking.
Thank you, sir. May I request Major General